My name is Scott R. Anderson. I'm a fellow at the Brookings Institution here in Washington, D.C. I'm also the general counsel and a senior editor for Lawfare.
Well, thank you for participating in this project. And
Sure.
um, I tapped you because you seem to know a lot about what's going on with law enforcement, the Trump administration, and this national deployment of National Guard and kind of ICE running around doing whatever they feel like doing. Could you kind of just give us a brief overview of the lay of the land as to what basically the three law enforcement agencies are doing at the moment? Like, what is the National Guard doing in these cities? What is ICE doing in these cities? And how does it kind of interact with local police?
So it's a really complicated question that has a lot of moving parts. I'll start with federal law enforcement, which I think is a little different in the details, but kind of categorically, kind of one bucket of fairly homogenous activity, particularly from a legal authorities perspective. Then I'll talk about the military a little bit, which is both the National Guard and actually active duty military in a few contexts, which is a longer, much more complicated picture. And they all both intersect in different ways with local law enforcement. Um, so the federal law enforcement task. Federal law enforcement is generally primarily tasked with enforcing federal law. And in theory, that's really the only thing they have the legal authority to do. That is not a light category, right? Like federal law governs a lot of what we do in the United States. It is a dominant legal system, but it's not comprehensive. The Constitution only gives the federal government the authority to regulate those issues that are subject to federal authority. So, pursuant to one of the express delegations of authority to Congress, that's in Article 1, Section 8 of the Constitution. Um, uh, and the federal law enforcement, in theory, is only supposed to be doing that. Or they often act in ways pursuant to something that we'll talk about in the military context of what in the military context, but also in other contexts, is often referred to as the protective power. An idea that there's also, in addition to the express authority to enforce federal law, there's kind of a lot of implied authority to preserve, protect, and secure federal resources, whether it's personnel, whether it's facilities, because if you weren't allowed to do that, you wouldn't be able to enforce federal law. And there's, some academic debate as to whether that is an inherent constitutional authority or an implied statutory authority that's just kind of one can infer from Congress enacting laws. The truth is it's a little bit of both. And then there's actually a lot of express statutory authority Congress has enacted, particularly since the middle of the last century, that has expressly set out rules for governing how federal law enforcement can protect federal facilities, properties, and things like that. So when you see ICE agents or FBI agents or ATF agents or any of these other federal law enforcement agencies deployed around the country, they're almost always enforcing federal law. And lately that has meant primarily immigration law, which is federal law. And there is, the federal authority to enforce immigration law. Um, there's also sometimes, and this varies state to state, something called peace officer status. That's where a lot of states, sometimes as an automatic matter, sometimes when certain requirements are met, give federal law enforcement officers peace officer status, which basically means they also have some authority to enforce local law. That's a practice that's pretty well established, but essentially is just meant to improve interoperability and cooperation. And because federal law enforcement violations often coincide with violations of state law, it just makes law enforcement a lot easier and a lot cleaner to be able to for them to do both, and especially if they end up collaborating or working on task force together, things like that. But when you hear about federal law enforcement going around the country, they're usually enforcing federal law, sometimes quite aggressively, sometimes in ways that are problematic, particularly on the tactical level. Frankly, while there's maybe good reasons to sympathize with many of the people who are facing the difficult end of immigration enforcement. In many cases, they are people who have either violated immigration law or were here on a status that Congress has given the executive branch a lot of discretion over whether to maintain or not, and that the executive branch is now restricting. And you can disagree that on a policy level, except for some gray areas. For the most part, that is legally something that's within the federal government's authority to do. Doesn't mean you can do anything to do it. That's where you get run into questions about like masking and overly aggressive tactics and things like that that are being litigated in places like Chicago right now around federal law enforcement about how they go about that. And there's some interesting questions about state and federal law that we can get into. But that's kind of what federal law enforcement is doing. And that entails coordination and cooperation with local law enforcement. It does not mean federal law enforcement is enforcing local laws, except where they are doing it as peace officers with the authority given to them by states, or in Washington, D.C., where Washington, D.C. has a kind of a unique status. While it is self-governed, it is not a state. It is a product of federal law. Its self-governance is a product of federal law. And in particular, in Washington, D.C., huge swaths of it are federal property, whether it's federal parks, federal buildings, stuff like that. So there is a much more practical federal integration of federal law enforcement and local law enforcement here in Washington, D.C., where I live, which you're seeing here out my window. So it's a little more complicated picture. They're a little more integrated than it might be in other places. That's the federal law enforcement mission. Not terribly complicated, more just a difference of scale and tactics than in terms of scope of legal activities. The military is a really different story. That's where things get really complicated. And I think it's really useful to think about what's happening right now in regards to the use of the military domestically in three categories. And I'm only going to talk about the most recent deployments to states. There's also things like longstanding deployments of troops to the southern border or around the country during COVID relief. We can get into those, and some of those deployments are ongoing. And I'll mention some of them along the way in explaining these recent deployments. But for the recent, more controversial deployments, the Trump administration has pursued since this past summer, they can be broken into three buckets. One is what I call non-consensual deployments. These are deployments to cities in states where the state government has not consented or requested, in fact, generally has opposed those deployments. That is California, where that actually happened over the summer, and then Oregon and Illinois, where we know deployments are planned but have been stopped by judicial proceedings currently. Then we have consensual deployments, which is situations where while city authorities or local authorities may not agree, state authorities have invited the cooperation with the federal government and have mobilized their own National Guard and sometimes outside National Guard to assist in certain areas. Right now, the clearest example of that is Memphis in Tennessee, where the state governor over the I don't know if express objections actually, but over certain reservations, certainly by Memphis city authorities, has decided to deploy the state National Guard and accept foreign state National Guard into the state to help with some law enforcement functions there. And then you have Washington, D.C. as its own weird test case. That is way more complicated and worth getting into, but doesn't really tell us anything about what's or much about what's happening in the rest of the country. The non-consensual bucket, where a lot of the litigation is focused on, where a lot of legal challenges and attention is understandably focused, is premised on two different legal authorities. And those dictate what those forces can do there. First, in federalizing and calling up state National Guard troops, which the Trump administration has done in all three of those states. And I guess let me take one step back here. The thing to bear in mind is that National Guard troops that exist in every state are a unique entity that is the modern successor of what were called the militia at the time of the Constitution. At the time of the Constitution, there was no assumption that there was any standing military whatsoever. The Constitution instead gave Congress the authority to raise and stand up an army and a navy. And then it also gave Congress the authority to call forth the militias of the states in times of invasion, of insurrection, or to enforce federal law. That authority has always been a legislative authority and remains to be understood that way today. But for a long time, Congress has used that authority to enact certain guideline statutes that give the president a lot of leeway in how to call forth those troops, or at least it allows the president to kind of initiate the process. And that's what's under contestation now is those provisions. In 1903, Congress established a new system for handling state militias. And that's the National Guard system, what came to be called the National Guard system. And the name didn't change for a couple more years. And the National Guard system basically said, look, when we have 50 state militias, or it wasn't 50 yet at the time, but 48 state militias, whatever the number was at the time, they're trained differently, they operate differently, and when we have to federalize them for war, they don't fight the war as well as they should because they're not trained to work together. So instead, what we're going to do is we're going to take every person who's a member of a state militia and we're going to dual hat them. when they join a state militia, which we're going to rename National Guard in a few years, they're both signing up to become the militia of their state, the military of their state. And that means they're under the command of their governor and governed by state law when they're in that capacity. But they're also going to be signed up to become members of the National Guard, which is a federal military. And so when the president, pursuant to authority given to him or her by Congress, calls forth, as authorized by the Constitution, the state militias, now the National Guards, or what we call today federalizes them, brings them under his command as opposed to their governor's command, they become parts of that National Guard force. And that is often colloquially referred to as state active duty or SAD status when they are under the command of their governor, or Title 10 status when they're under the command of the president. And it's called Title 10 because that's the title of the US Code that contains all the DoD authorities. Then, just to complicate things further, there's a third bucket, which is called Title 32 or hybrid status. That's kind of emerged, I think, really since the middle of the 20th century. I don't actually like it's complicated to tell exactly like when and how it emerged. Its usage has leaned in this direction in the last few decades, where essentially these are situations where troops, National Guard troops, will stay under the command of their governors, technically, but their governors will volunteer them for missions that are under the direction of the federal government, and that are often funded by the federal government, not always. This is mostly things like training exercises where like the state guard, the state, National Guard commander under state authority will say, hey, this unit, go participate in this joint exercise DoD is running. DoD is going to pay for you to go there. You're going to follow we instruct you as your commanding officers to follow their general directions, but we're still your chain of command, but you're going to follow their directions. And it was just a way at the time to, primarily, I would argue, get these different units to collaborate in different types of training and joint exercises, but it's evolved since then and now is used for a bunch of complicated federally funded missions that go much broader than that. Okay, so that's all preface. So let's start with the non-consensual deployments in Oregon, Illinois, and California. California is the only place it's actually happened. These are premised on two basic legal authorities. One is at Title 10, Section 12406 of the U.S. Code. And this is a law that looks like, but is not, and is a really important thing to bear in mind, the Insurrection Act, the much more notorious law that allows the president in certain exigent circumstances to call forth the state National Guard and deploy the armed forces to do different missions to suppress insurrections and enforce federal law. But it looks a lot like that. It was actually enacted as part of the 1903 law that established the National Guard system, also known as the Dick Act. This provision basically says where there's an invasion or where there's a rebellion or where the president cannot enforce federal law with the regular forces, a term that has become of very, very big interest, particularly the Supreme Court in the last week or so at the time we're recording this. Where those conditions are met, the president may call forth or federalize state National Guard units. That's all it says. Up until the Trump administration, this provision had never been used, or maybe had only been used once by the Nixon administration in response to a postal worker strike in the 1970s. Had never been used to mobilize troops for this sort of thing before, to actually be engaged in a mission deploying somewhere. Again, the closest you got is during this postal worker strike, the Nixon administration used, I think it was New York State National Guard to act like postal workers in a mission that was actually like widely on audit determined to be ineffective because they had no idea how to do postal worker work. Other than this authority has always been understood to be a mobilizing authority that's usually used in hand with the Insurrection Act, which separately says in similar exigent circumstances, you can federalize the National Guard or the military and also deploy them for certain purposes. 12406 was understood to be an effort to clarify you can still do this in these circumstances, even though we're restructuring the state militia system, it still applies. That's at least one conventional way it's been understood. But there's an argument now that it's actually doing more than that. Regardless, the Trump administration has said, look, in these states, there is a rebellion happening in terms of protests against our federal law enforcement efforts. And the president has determined he cannot enforce the federal law with the regular forces. So both prongs 2 and 3 of 12406 have been triggered. Prong 1 about invasion, no one's arguing that yet, although the Trump administration has described legal immigration as an invasion in a separate context. So I wouldn't rule it out as a possibility, but they haven't done it yet. And so they say, okay, these prongs are met. We're federalizing National Guard units in California and in Oregon and in Chicago. They have also argued, well, even though this has always been used as a kind of mobilizing authority, meaning it just federalizes the troops, it doesn't give us authority to do anything with them. We actually think it does do that. And they've argued, and statutorily, we actually think this is an exception to another important law called the Posse Comitatus Act, an act that since the mid 19th century has restricted U.S. officials' ability to use federal troops for law enforcement purposes within the United States. Um, those latter two arguments, notably, both the mobilizing authority and the Posse Comitatus Act exception arguments, the government has consistently made, including all the way to the Supreme Court, under the Trump administration, not and there's elements both existed in prior executive branch legal opinions, so it's rarely been the subject of litigation. But notably, the Trump administration isn't directly relying on either of them, or not exclusively relying on them in its argument as to why it's doing what it's doing. Because what it says it's using these troops for, is that it's deploying them in the states in a way where their sole mission is to protect federal personnel and property, and specifically ICE and CBP personnel property. So these troops are being deployed to protect those facilities, and then they essentially ride along or provide at a slight remove security support for ICE and CBP and other federal law enforcement personnel as they're usually going about their immigration enforcement mission. And they say, the Trump administration argues, this does not violate the Posse Comitatus Act because the troops themselves actually aren't doing any law enforcement. They're just defending the federal personnel and property under this idea of the protective power I mentioned earlier, this idea that the president has an inherent authority to use federal resources, including the military, to defend federal personnel and property. And this is an idea that executive branch has kind of developed since the mid to late 19th century onward, but has never really been tested seriously in the courts. That's important that they're relying on that limited scope of activity, because it means that even though they make these arguments about 12406 being Posse Comitatus Act exception and authorizing statute, it doesn't actually have to rely on them. They actually have this idea of inherent authority and the protective power that they're arguably, I would argue, relying on more squarely, because they're constraining their activities to that narrower theory. They're not, at least as they interpret it. Regardless, there's still very serious questions as to whether they are correct that even that limited scope of activity doesn't push up against Posse Comitatus Act barriers. And they've actually, the only court that's looked at it, which is a district court in California, ruled that, in fact, they are violating the Posse Comitatus Act, although that ruling has been administratively stayed by the Ninth Circuit Court of Appeals. So all that is to say, oh, and I should note, this includes the rules that govern the active duty troops, because in California, there were also active duty Marines deployed to this mission. So they don't need 12406. They're already federalized. They don't need to be brought under the command of the president like National Guard troops. But they are doing a mission under the protective power solely. So they lean on that exclusively as a sort of authorization, because 12406 doesn't really apply to them. It doesn't say anything about regular armed forces. All of this is to say, this is why when you look at these non-consensual deployments, the mission scope of the military is actually much narrower than you might think. It is, again, only to support federal law enforcement efforts. They can't go around generally pursuing law enforcement or supporting law enforcement around the cities and states they're operating in, because there's a nexus to federal authority. They can only do it for these federal governments. And notably, in the executive order and in some reporting around the deployments in Oregon and Illinois, it seems the Trump administration, and they actually say this expressly in one of the orders, actually went to the state governors in both cases and said, we want you to consent to a broader mission set under a different legal authority that's using the consensual bucket we'll talk about in a minute, so that we can do more stuff. But if you don't do that, we're going to come in and we're going to do this under this 12406 authority anyway. Neither governor or state government consented to that, and so that's where we are. But the Trump administration seems to want to do a broader mission set, and they seem to, at least thus far, be of the view that they need the state government's consent to do that, and that hasn't been forthcoming. So they've relied on this tool that allows them to federalize state National Guard troops before a more limited mission scope. And notably, once National Guard troops are federalized, they're basically active duty troops. So when the president deploys California State National Guard to Oregon, as it contemplated doing before it was stopped by judicial order a few weeks ago, there's not necessarily a state-to-state relations problem with that. Because even though those, sometimes you have people like Governor Abbott in Texas saying very supportive things about those missions, they're actually not acting under their governor's authority at that point. They're only acting the federal government's authority. The governor can't even say no if the president mobilizes them. That's part of the Dick Act structure. So that's what the non-consensual bucket looks like, and that's what's being litigated. And the current litigation is over at the initial phase whether 124063 has really been triggered. People are contesting whether there's a rebellion. Notably, no court has determined there's a rebellion. No court has leaned on that provision, even though the government has advanced it. The Ninth Circuit, two panels of the Ninth Circuit, overruling a district court judge, did determine, we think that under the third prong of 12406 about enforcing federal law, the president has reasonably determined that that he may need to federalize National Guard troops to enforce federal law because he could not do it with the regular forces. That decisions by those panels of the Ninth Circuit, the second one, which relates to Oregon, is now being reheard en banc and has been vacated. So we don't know if they're going to come out a different position, but the first panel opinion regarding California is still in place. Notably, the Seventh Circuit, on reviewing a district court opinion, both the district court and the Seventh Circuit reached the opposite conclusion. They said, at least in Chicago, what's happening in Chicago doesn't even rise to the level of satisfying this standard under what all the courts agree is a highly deferential standard to the president. So they say this should be a highly deferential standard. The president's view should weigh extremely heavily into whether or not this is a rebellion or whether or not this is necessary to enforce federal law, and that can't be done with the regular forces. And we still think under that standard, this loses. Only the district court in California has even reached the Posse Comitatus Act protective power question as to whether those are dealable, but all the other district courts will have to encounter that if military deployments proceed in Portland or Illinois, because that's the next argument that'll come up. It's come up in DC too, in a way we'll talk about in a second. Notably, right now, the Seventh Circuit opinion was appealed to the Supreme Court, and the Supreme Court has, interestingly, as of yesterday, glommed onto a very unorthodox part of 12406 in reaction to an amicus brief filed by Marty Lederman, a legal scholar here at Georgetown, a former senior Justice Department official in the Biden-Obama administrations. And I think it's fair to call Marty, who's a very smart guy, one of the most creative legal thinkers of his generation, in his kind of Sphinx-like ability to really identify interesting legal aspects of the stuff that are quite compelling. He pointed out, well, what does this really mean in 12406.3 that the president has determined he cannot enforce this with the regular forces? Most people, including all the litigants in the litigation, as far as I can tell, and most legal scholars, and I'm not going to pretend like I didn't just kind of ride along with this, looked at this provision and said, well, we assume that means, like similar language as in the Insurrection Act, that means that the president can't enforce it with the usual resources available to him, through normal proceedings, normal order. And that is actually what the Insurrection Act more or less says, like through normal judicial proceedings. But he pointed out in the 1908 law that installed that language, which lightly amended the provision as it was originally enacted in the 1903 Dick Act. In that 1908 law, the regular forces was used both in other parts of that law and more generally by Congress and in dictionaries and by the Supreme Court and by lots of other authorities to instead mean regular military forces, active duty military forces otherwise. So if you read the provision that way, it would mean that the president could only deploy state National Guard or federalize them after he determined he couldn't enforce federal law with the active duty military forces, something the president hasn't clearly determined and hasn't even tried to do. And not only that, would be kind of weird to do today, because today we think of the National Guard as less intrusive than active duty military. But he's only tried to do that in California. And again, the Marine deployment there was not actually the main thrust of the mission. It was really mostly California State National Guard. So the Supreme Court asked for additional briefing on this argument that's going to take us through mid-November, and that appears to be the issue that they've glommed onto, at least on this initial impression. And notably, they've held off on staying the Seventh Circuit's opinion, which is what the Trump administration asked them to do. They asked for an immediate administrative stay, and they've declined to do that, which is a sign that I think the court is skeptical of the position taken by the Trump administration, and it might be because of this unique angle Marty has identified in 12463. That is hugely complicated. Is there any part of that worth me elaborating or questions? I have these two other buckets I should talk about, but I know that's a lot. But
Yeah.
I thought it was worth getting it all out there.
I think it's interesting, but yeah, the other two buckets would probably be good because I have a couple of follow-up questions when you're done. So.
Okay, perfect. Luckily, they're somewhat more straightforward. At least DC is so complicated, it's worth just kind of speaking at a higher level. The consensual bucket, the Memphis, although notably like New Orleans has been talked about in another deployment of this model, works on a different legal authority. Here, these are cases again where the state governor is supportive of working with the federal government on this mission. The federal government has said we're going to use funds and resources available to support National Guard in doing conventional law enforcement. So what they've done in these cases is that they have used an authority called Title 32. So this is a hybrid status authority, 502 parenthetical F. And what this authority says is essentially, I'm paraphrasing here because I don't remember the exact language, but it basically says that, the federal government can, or that state governors can volunteer their National Guard troops for different federal missions, such as training, joint exercises, and other duties. And the executive branch has interpreted that other duties very open-endedly in a way that stretches the limits of general statutory interpretation, I would say, but nonetheless, they've done it and they've been doing it for a long time to basically mean anything. And in fact, that's what the government has essentially argued, that we can basically do anything we want under the statutory provision. And that other activities language they have used to take Title 32 hybrid duty status troops and deploy them to lots of different missions around the country to do different things, whether it's COVID relief in different cases, whether it is in a bunch of states. This has been used to support ICE missions where the governor is supportive of them, and they take some of their National Guard troops under state authority and contribute them to these Title 32 missions. So that's happening in like dozens of states around the country. That hasn't gotten much coverage. Memphis is a little different, where there the governor is saying, okay, we're going to volunteer them, or take our National Guard troops, federalize them, or sorry, not federalize them, put them under Title 32, where they're still under state command, but they're in a program funded and kind of directed by the federal government. And that program is going to be to support our local law enforcement in the city of Memphis. So you have these Tennessee National Guard coming in. There's talk about other state National Guards participating as well, although I actually haven't seen confirmation as to whether that's happening, which presumably the governor is consenting to for those coming in. And that this authority is notable because these troops are under state active duty status. The executive branch's position has long been they're not subject to Posse Comitatus Act limitations. The Posse Comitatus Act only limits federal troops. These aren't federal troops. These are state troops that happen to being volunteered for a federally funded directed mission. I'm not aware of that theory ever having been tested in court, and it is a point of contention in litigation in DC. Notably, there has not been federal litigation yet around this in arising out of Tennessee that I'm aware of. Although, in the case of Tennessee, we've actually seen people associated with the city of Memphis. It's not the city itself, but I don't believe, but certain people challenge the deployment of Tennessee National Guard under the state law because they're saying the state constitution actually constrains this use of National Guard troops. But regardless, that's the mission happening in these consensual states. And it's a broader mission set than happening in the non-consensual states because they're using this 502F hybrid authority. Because they say, well, we're not subject to the Posse Comitatus Act because we're working with the consent of state authorities, or at least the state governors. State legislatures haven't generally had to weigh in on this, although query whether they should have to. They are able to do a much broader range of law enforcement activities because there's no Posse Comitatus Act limitations. And so they're doing a much more integrated role, covering a lot of things beyond just federal law enforcement interests like counter-immigration, although that's usually also happening as well. So that's a consensual model. And that's the model, again, that like the Trump administration has tried to, I think arguably coerce Illinois and Oregon into voluntarily adopting by threatening to do what they ended up doing, which is the non-consensual 12406 deployments. Then you have Washington, D.C. Washington, D.C. is a mess. A great city. I love it, my hometown, but it's a mess legally. Because of its federal status, it has its own National Guard like a state. But it's a product of Congress. And Congress, when it established that National Guard, said, you report to the president, not to the mayor. There's actually legislation to debate changing this after 2020, where the president did something very similar to what he's done now. It's much controversy during Black Lives Matter protests, but it was never enacted. And so what has happened in this case is that the president has said, okay, I am your commander, state National Guard, or DC National Guard, equivalent of state National Guard. So I'm directing you as if I were your governor to do a bunch of these duties. You're not being federalized, so you're not subject to Posse Comitatus Act limitations. And there are DC code provisions that limit when the president can direct National Guard troops to do various sorts of activities, including things that look like law enforcement. But one provision requires a request by the mayor or certain other city authorities that hasn't occurred. Another one says, yeah, you can direct them to do exercises like 502F, exercises, joint training, or other duties. And they're leaning really hard on that other duties again. Not unprecedented, the executive branch has done in the past, but they're basically saying, well, this other duties language means we can basically use the DC National Guard. The president can use them to do whatever he wants. It's up to his discretion. Again, arguably stretches the limit of how you would normally read those statutes, but it's also what the executive branch has been doing for a long time. So there's kind of countervailing pressures there. Notably, also, DC, because it's not a state, has had a number of other states operating there, where other states have volunteered their state National Guard contingents to come to Washington, D.C. Under that 502F authority I described earlier. Again, they're there not under federalization. They're still under their state command, but they're being volunteered for a federally funded, although actually the funding is not clear how much federal funding is going to this, but federally directed mission. And that's why we have, like, here in DC, you can look out my window right now. I just saw a few minutes ago, like, National Guard troops walking by. And they probably are from Ohio or Florida or Texas or one of these other states that's contributed to this mission. I don't know which states have folks here right now. That mission set is broader. Notably in the past, like in 2020, when the president did this, they still mostly constrained them to kind of federally protective missions. They were mostly like defending memorials and like doing other stuff. Now there's a bunch of reports of like National Guard troops like raking leaves and picking up trash on federal park property. Um, you know, where it's kind of interesting because it seems like they're teeing themselves up to have a legal argument that they can use these troops to do whatever they want because they're not subject to Posse Comitatus Act limitations. But nonetheless, the president is mostly using them for federalist duties. I'm guessing that's because they think Title 32 still needs to have some sort of federal nexus, the 502F authority. So like there has to be some federal interest underlying it. But nonetheless, they've been used to do a wide variety of things in DC. They're all over DC, including just kind of walking around. And because DC has so much federal property here, even if they were limited to protecting federal property, usually that's been interpreted for both federal law enforcement and for military as mean like the property and a reasonable perimeter. And if you connect all those perimeters, you can like walk through huge swaths of downtown DC without ever getting outside the zone of federal property, right? So there's not much constraints on what they can do in terms of where they can operate, at least here. DC National Guard have been doing much more direct law enforcement activities because they are seen as having that authority, and they're actually, it's like kind of established practice of them doing that more often. Certain state National Guards may have been deputized here as well, but it's a little unclear to me exactly the sole scope of that duties. That actually was the subject of litigation in a hearing last week, and something I have on my schedule to dig into to figure out exactly the scope of where we landed of what they're doing. But the long and short of it here is DC is such an odd case because it has all these local authorities that don't actually match what exists in the states. And notably that 502F mission, which is non-consensual. The mayor said, the mayor has been a little cagey about it, but generally the suggestion is we don't really like having these foreign National Guard troops here. Among other things, it's like damage the local economy because people are being scared out of going to nightlife and going to restaurants because there are armed soldiers around. At least that's the explanation many people are offering. Here, that's not something that clearly can happen in other states. Because if one state were to volunteer their troops to be deployed to another state over that state's objections, that looks a lot like an invasion. And that is something that the Constitution pretty clearly says one state is not allowed to do to the other. In fact, there's a federal obligation to protect states from invasion, including from each other. So that would be a real problem if they were trying to use 502F for non-consensual missions. But in DC, there's no state sovereignty that's reserved to the states like it is for the federal constitution. And so consent doesn't matter as much. And it is kind of federal authority. And the president is the head of the federal government. So the assumption he has a lot of authority there. It's worth noting the DC Attorney General is filing a lawsuit that attacks almost every angle of that architecture, and makes a lot of assertions about the president's or the city's self-governance under existing statutes and what it's entitled to. It is super far-ranging litigation. It's very interesting. They're launching a lot of different arguments. Some probably will not win in the end. Some might. They're also making a bunch of arguments about why putting foreign state National Guard under the direction of DOD violates Posse Comitatus Act, even if they are state National Guard, not subject to the PCA directly. It's a lot of interesting arguments that will come out of that. So far, the district court has just heard argument and briefing on that. We haven't gotten a decision yet unless it happened in the last hour or two. I haven't checked.
Well, that's a lot of information. Thank you for it all.
Yeah, sorry.
I
It's very
guess
complicated.
it is, and I guess just to kind of cut through the the noise of the media versus what you kind of just described, because I think when you get right into it, most people don't understand the complexities of what you just explained and just see National Guard, heavily armed men in masks and tactical gear doing stuff on their streets. And I guess, as you explained, why are we seeing the tactics we're seeing? And is it intentional that some of these tactics in non-consensual cities are purposefully ramped up? Is that a question you can kind of address?
It's a question I can reiterate some views I've heard. I don't think I've done enough dive personally into some of the past practice to speak of competence of it. Um, and here I think you really do have to segregate California from DC, and to some extent Memphis. In DC and in Memphis, this time around, setting 2020 aside in DC, where we did have some state National Guard involved a little bit, although actually less, not that common in some like riot control sort of instances. In DC, there you don't see quite federal, at least the military is not being used for those kind of aggressive tactics. As there have been in many cities, cases of federal law enforcement using more aggressive tactics, but the military hasn't been involved in that. Like the National Guard presence here really is mostly thus far been young men and women in camouflage, sometimes usually armed, sometimes only armed with sidearms, sometimes armed with assault rifles, but usually not in like tactical gear, being a presence and like walking around neighborhoods and like occasionally coordinating with law enforcement in like traffic stops or other things like that. But it's not quite the same as what we saw in parts of California. There you did see military as well as law enforcement, often in a way that was difficult to distinguish, a point of real contention and concern by the district court judge that evaluated Posse Comitatus Act restrictions. Um, Engaging in riot control, essentially, particularly around protests and around ICE operations that they were actively supporting and facilitating, or maybe not facilitating, actively providing security for us to give it the framing that the Trump administration has put around it. So, the military's involvement in some of the most aggressive ICE tactics, my understanding, has been relatively limited. ICE and certain other federal law enforcement agencies like CBP, as has become an issue in separate litigation in Chicago recently, has been doing very aggressive things about tear gas. There have been cases of them opening fire on people, putting guns in people's faces, really stuff that frankly would be considered very inappropriate for federal law enforcement generally. And why this is happening is a good question that people need to ask the Trump administration and the leadership there, which is happening in the course of that litigation. The guess of many people, and I think this is very plausible, is that this is part of a broader tactics that the Trump administration wants to be as scary on immigration as possible, because remember, they're not just trying to enforce immigration laws, they want people to self-deport. And that is working to some extent. They are trying to scare people whose status might be in question or be an issue, even if they're peaceful here, to say, I don't want to put my family through a sort of violent confrontation and I'm going to self-deport. And they want to deter people from coming here. And they think the way to do that is to look as brutal and inhumane as possible. I strongly suspect that's the motivation, but I would put it to them to explain it themselves. Is the sort of aggressive tactics strictly necessary? You should talk to a law enforcement expert about that. My non-expert, but somebody who at least has monitored national security and related law enforcement operations as professionally for a long time, is that that's a hard case to make in a lot of these cases. Certainly, there are cases where you've seen protesters use very aggressive tactics against ICE and CBP agents in certain contexts. That has happened in a handful of cases. We shouldn't ignore that. And look, if you're an ICE agent, CBP agent trying to do your job, that is scary. And we have at least one case that has been the subject of criminal prosecution in Texas where you saw a law enforcement officer get shot and injured, not killed, I don't believe, but injured as part of a protest that's now the subject of a criminal prosecution by a Antifa cell, which is, the framing the administration has put on it. Regardless, those real incidents, it's hard to reconcile those handful of incidents with the scale at which these tactics are happening or being deployed in different contexts. So while there may be instances in a bunch of cases where, masking and tactical gear and all this stuff is appropriate, it seems like it's really much more of an intimidation tactic. And the masking and things like that, frankly, is probably part intimidation and part ICE agents and CBP agents not wanting to subject themselves to scrutiny. And again, this has been the subject of litigation in Chicago and will be the subject of more litigation in more places, because this raises a lot of questions about, you know, is this appropriate or not? And you're beginning to see states like California enact laws that are intended to raise legal questions about, can the law enforcement agents really do this while masking or while pursuing some of these tactics? And we're going to see more of that. But for the moment, the Trump administration appears to be leaning into the ambiguity around this to try and put forward as fierce a presentation as possible as part of a broader intimidation campaign. That is my educated guess, but I really put it to them, and I hope courts and reporters do put it to them to explain themselves.
And thank you. That's pretty good explanation. I think the my final question for you, and I believe this is probably an unfair question to ask you, but I'm going to ask anyway. If both sides, so if the Trump administration got everything they wanted, and the states that were non-consensual got everything they wanted, what are the best case scenarios for each of them, and what are the worst case scenarios for kind of law enforcement in states and federal? Does that make sense?
Give it to me one more time just to make sure I'm responding
So
appropriately.
if both sides got what they wanted, what does that look like? And then if what is the outcome for the other side if Trump administration got everything they wanted? What are the states facing? And if the states get everything they want, what is the Trump administration facing?
I see. So it is actually a really complicated question, because it's not clear to me whether these legal fights are over what's actually happening or trying to lay down lines and precedents for arguments that may yet to come that address other types of activities. So let's start with the government, the Trump administration, right? If the Trump administration has argued that 12406.3 determinations about whether you can federalize these troops are entirely up to the president's discretion, the courts have no role in reviewing them, and they cited some Supreme Court precedent to back that from 1827 Martin v. Mott is the case, and Luther v. Borden 30 years later. That argument has, for the record, been rejected by every court who's looked at it, and it's almost definitely a loser. I think even at the Supreme Court. Although every court has also said it is a highly deferential standard. It's not absolutely deferential. Of course, the courts have to look at this to some extent, but the president gets a lot of benefit of a doubt. And there's pretty broad consensus about this among every appellate court who's looked at it, and lower court. That said, if the president really got what they want, they would basically have the court saying, the president can invoke this statute to federalize troops and then direct those federalized National Guard troops. Anytime that the president determines there's difficulty enforcing federal law or that there's unrest that rises to a level of rebellion, which is a low threshold, as we've seen, the stuff happening in Portland and Chicago and California is like not up to the level of civil unrest we've had even in the last 5 or 10 years in other contexts. I think it's a really hard argument to argue otherwise. So that means the president would have a lot of leeway under that statute. It raises the question then about well, what does that mean for other statutes? Because then you also have the Insurrection Act, which the Insurrection Act says under very similar exigent circumstances, the president can deploy active duty troops, deploy federalized state National Guard, and then deploy them to put down a rebellion or to enforce federal law. It is an express statutory exception to the Posse Comitatus Act. It's kind of the original one. So in theory, I think if you establish that the president has appropriately invoked 12406.2 and or 3, you've got a good argument that the president can also invoke one of those other provisions of the Insurrection Act, because the predicate conditions, while they're worded differently, are very, very similar. And importantly, if the president wins, it's going to be because he wins having secured an extremely deferential standard of review, and that standard of review will be based on case law that's actually about the Insurrection Act, not 12406.3. So I think really if the president wins on 12406.3, not only does he get to keep doing what he's doing now, which is the more limited mission set based around the protective power, it actually really does clear the way for a invocation of the Insurrection Act to do a potentially much broader mission set of the military being involved in direct law enforcement. Will the president do that? Who knows, right? He said he wants to invoke the Insurrection Act, but he hasn't before. He's been deterred. He was deterred in 2020. And maybe the president gets what he wants out of this. If what he really wants is to scare people with immigration enforcement, and to just have the optics of troops on the street, then he's kind of getting that already if he wins his way under the current legal fight. But if what he really wants is to do DC type missions where you see troops enforcing just the law generally, maybe you move towards an express Posse Comitatus Act limitation. Notably, that would still be just to enforce federal law. And the thing people need to bear in mind is that even if the president invokes the Insurrection Act, it does not install martial law. Every constitutional right you have still applies. The president has not and will not support and cannot, without Congress, suspend habeas corpus. So it's the president can't do anything with the military that he can't already do with federal law enforcement. The president's just being allowed to mobilize the military to enforce federal law, which is already what federal law enforcement does. But there's an optic, there's a cultural limit consultation, there's like a lot of capacity questions and things like that. There's reasons why people are scared of that. They're very reasonable, but it's not martial law. We have to bear that in mind, and we shouldn't be persuaded otherwise. We have all the same bundle of legal rights, and we can enforce them through the courts like we have always been able to, and should. But that's what the president gets what he wants. He gets to keep doing what he's currently doing, which is a limited mission set, but it's substantial. It gets him to the optics he wants, and he may get a precedent that helps him build the case for a further mission set. If the government, or pardon me, if the states get what they want, the challengers get what they want, the president is stopped in his tracks. 124063 does not apply to these cases. And that means that the president can't federalize these troops. He could still deploy active duty military, particularly if the Marty Lederman's argument about the regular forces is invoked in 12463. In fact, that would suggest the president is supposed to, as Congress envisioned in 1908, deploy the regular military first, the active duty. But he would still be limited to the protective power there unless he invokes the Insurrection Act or something. The protective power, if the states get their way, is going to be much more constrained. It isn't going to allow them to operate so proximately to federal law enforcement as they have been. The question this raises then is that what does that mean for the Insurrection Act? There are some people who have argued, and I think Jack Goldsmith said something to this effect recently as a wonderful advisor and friend of mine and a colleague and friend of Lawfare and writes for a separate blog, Executive Functions, as well, where I believe he put forward this argument, where he suggested, as I recall, apologies to Jack if I'm misquoting him here, that the Insurrection Act could still be available if 12463 were to lose and the president needs to go. Then he could go to the Insurrection Act. And there are reasons to think maybe the president would get more deference to the Insurrection Act. In particular, the one provision of the Insurrection Act that relates to the enforcement of federal law expressly says where the president determines that he cannot enforce the federal law through the normal judicial process, which is not said in the other provisions regarding insurrection and regarding the enforcement of protection of federal constitutional rights. So, like, weirdly, in that one provision, there's an argument that maybe this means even more deference to the president. So maybe we can't second guess it. That said, the case law that's being cited in arguing about the level of deference that's entitled in regard to 12463 all relates to the Insurrection Act, all relates to this language already. I think this language was in the Insurrection Act in 1827, 1840s when Martin v. Luther v. Borden come together. I would want to double check that. But regardless, the key point being is that it's already saying the courts have already given the executive branch a very highly deferential standard of review and have found it wanting. So is there really going to mean that they're going to somehow go to the Insurrection Act and say there's even more of a super high level of deference and now you get your way? My instinct tells me no. My instinct is that 12463 and the Insurrection Act rise and fall together. And so I don't think that, I think if you defeat the Trump administration on 12406, that means that they're probably going to lose on the Insurrection Act too. They can try, and they very well might try, but they're probably going to lose on that regard too. So that in that case, if I'm correct, then the states would also be getting not just a defeat of what the president's currently trying to do, but a big win that's an important precedent for them if he were to ever try and invoke the Insurrection Act to do something similar in the future in similar circumstances. But if I'm wrong, then it would mean that, well, yeah, the states have won on 12463, but that might just give the president more incentive to invoke the Insurrection Act. And maybe they'll stand a better chance on the Insurrection Act. But it's going to start the same litigation cycle over again because it raises a lot of the same questions.
Well, thank you. And the Insurrection Act and how they're trying to label Antifa probably is a topic for another day.
Fair enough. Happy to come back and talk about it. I have lots of thoughts about that too, but it's
Yeah,
as complicated as this, so it could take us a bit longer.
right. And I have I would like to kind of delve into that because, but again, that seems less immediate, I guess, than what's happening now, and it's kind of more of a hypothetical, like what's going to happen.
Yeah,
Is that yeah?
it's fair enough. Fair
Well,
enough.
thank you for giving us a deep breath on military occupation and martial law, which I think most people are worried it's
We're not there yet. Don't worry.
imminent.
Martial law is a ways down the road. We're not. That's not even what we're talking about. So God willing, no one will get there.
That's right.